everyone, I am Vibha Chauhan and welcome to Chauhan Classes Funda Clear. So today I will explain chapter 7 from the Indian Polity book written by M Laxmikanth, and the chapter is Fundamental Rights. So as you know, fundamental rights, this chapter has a very large content, so we will be splitting it into parts, and this is the first part of this chapter. So fundamental rights, if we talk about fundamental rights, so India derived its inspiration from the American Constitution. In the American Constitution there is Bill of Rights, and from that we derived our inspiration. And fundamental rights covers from Article 12 to Article 35, and which come under the Part 3 of our Indian Constitution. And Part 3 of the Indian Constitution is also called as the Magna Carta. Magna Carta, as you know that Magna Carta was a charter issued by King John of Britain in 1215. And it was the first written document that was for the rights of citizens. So Part 3 of our Indian Constitution is called as the Magna Carta. And fundamental rights, if we talk about fundamental rights, they uphold the integrity, unity of the nation, they uphold the equality of all individuals, liberty of all individuals. So the fundamental rights are named so because they are guaranteed by the fundamental law of land, that is Constitution. Constitution guarantees them, they are justiciable, you can say that. And the fundamental rights, if we talk about fundamental rights, they are meant for the government of laws, not for the government of, you can say, men. So you can say that fundamental rights are very important for India, you can say for any country. And originally when they were written, the fundamental rights, there were 7 fundamental rights, but at present there are 6 fundamental rights. So now at present there are 6 fundamental rights, which are: first is right to equality from Article 14 to 18. Then comes our right to freedom, that is from Article 19 to 22. Then comes our right against exploitation, that is Articles 23 to 24. And then comes right to freedom of religion, that is under Article 25 to Article 28. And then comes educational and cultural rights, that comes under Article 29 to 30. And then last fundamental right is right to constitutional remedies, that comes under Article 32. So you may have noticed that I have started the fundamental rights from Article 14 and have ended to Article 32. So what about the other articles? I had said that fundamental rights come from the Article 12 to 35. So what about 12, 13 and 33, 34, 35 and 31? I have also skipped 31. So Article 31, that was former a fundamental right, that was earlier a fundamental right, that was right to property, but it was deleted by the 44th Amendment Act of 1978, and after that only 6 fundamental rights are there. And Article 12, 13, they do not provide fundamental rights but are related to the fundamental rights, so that's why they are also under the Part 3 of the Constitution. So let's begin with our first topic, that is features of fundamental rights. Features of fundamental rights. So what are the features of our fundamental rights? So there are many features of the fundamental rights, like some are available only to the citizens, while others are available citizens as well as the foreigners, and for legal persons, that are, you can say that companies, authorities, they are also provided for them. And there can be restrictions on them, the state can impose reasonable restrictions on them, but however those restrictions are reasonable or not, that are to be decided by the courts, and they are not sacrosanct or permanent, you can say that they can be curtailed or repealed by the parliament through an amendment, but through that amendment, the parliament cannot change, cannot destroy the basic structure of the constitution, the fundamental rights which are making the basic structure of the constitution. And during the national emergency, during the period of national emergency, there can be imposed restrictions on those fundamental rights, except rights guaranteed by Article 20 and Article 21, and Article 19, the 6 rights guaranteed by Article 19 can be, you can say that, can be repealed or can be, on those rights can be imposed restriction only in the time of external emergency, not in internal emergency, you can say that. And on the application of these fundamental rights to the paramilitary forces, to the members of paramilitary forces, to the armed forces, to the analogous services, can be or cannot be. This is to be decided by the parliament, you can say that. So there can be application to those as well as a restriction on those, that is to be decided by the parliament. And you can say that fundamental rights can be against state. They can be negative as well as positive. For example, negative in the sense they are imposes restrictions on the, you can say that, tyranny, on the, you can say that, arbitrary laws of legislature and executive, as well as they can give positive in the sense that they can give, fundamental rights can guarantee privileges to the citizens of India. So you can say that there are so many features of our fundamental rights. So our next topic is definition of state. Definition of state. So you may have heard that, you may notice that if you read fundamental rights, then there is lot of usage of the word state. Then what does this word state mean? So Article 13 is, so Article 12 is for this. Article 12 describe the word state. What is the state? Why is it used? How is it used in the constitution? So you can say that Article 12 says that describe the definition of state. That is government, you can say that, government and parliament of union government. You can say that executive and legislatures organs of the union government are state. You can say that government and legislature bodies can be state also, that is executive and legislative organs of the state government, and all local authorities, that are municipalities, district boards, panchayats, are also come under the word state, you can say that. And other authorities, other bodies, other companies that are statutory or can be non-statutory are also come under state. So you can say that all these come under state. All these companies, all these, you can say that, municipalities, all these legislature, executive come under state, and there can be action against them, you can say that. Because you can say that when fundamental right is violated, then a aggrieved person can directly go to the Supreme Court. There is no need for the procedure, that is first appeal to the High Court and then Supreme Court. The aggrieved person can directly go to the Supreme Court. So you can say that there can be restrictions again, there can be action against this state, you can say that. So next topic is laws inconsistent with fundamental rights. Laws inconsistent with fundamental rights. So Article 13 says that, Article 13 of our Indian Constitution says that any law that is inconsistent with or in derogation of any fundamental right shall be void. That is, any law that is made can be unconstitutional, can be declared as unconstitutional or invalid by the Supreme Court, you can say that, if they are violating any fundamental right. And the law, in terms of law, what do you mean? There is meaning, there is, you can say, the definition of law as well. Laws that are permanent laws enacted by the parliament, or can be temporary, you can say that temporary laws issued by President of India or the governor of states, like ordinances. They can also be a law. And what can be other laws? That are any statutory instruments like bylaw, notification, rules, regulations, they also come under law. And any other, you can say that, any other uses, legislative uses can also be a law. So you can say that not only legislative, but all these come under law. And if these are made in violation, in derogation of fundamental rights, then they shall be declared as void by the Supreme Court. But an Amendment Act is not considered as as an, you can say that, as a law, and hence they can be made to, you can say that, to curtail, to repeal the fundamental rights, to violate the fundamental rights. However, in the Kesavanand Bharati case, the Supreme Court declared, so the Supreme Court held that the amendment is not a law, but it cannot destroy the basic structure of the, you can say that, Constitution, the fundamental rights that are making, that are, you can say that, forming the basic structure or basic feature of the Constitution. So you can say that Article 13 says about laws, you can say that, and these are also related to the fundamental rights. They are not providing, the Article 12 and Article 13 are not providing fundamental rights, but are talking about fundamental rights, and these are very important because most of the questions are also put up from these, you can say that. So our next topic and our first fundamental right is right to equality. Right to equality, that is our first fundamental right guaranteed by the Constitution of India and covers from Article 14 to Article 18. So our first subtopic is equality before law and equal protection of laws. Equality before law and equal protection of laws. So Article 14 of our Indian Constitution says that the state shall not deny to any person equality before law and equal protection of laws. And this right, this Article 14 right, is for every person. Person here includes foreigners as well as citizens of India. So equality before law, that is British origin, that is a concept from British origin, while the equal protection of laws is derived from the American Constitution. And this concept, that is equality before law, you can say that is negative. It's negative in sense, while the equal protection of laws is in positive sense, but both are meant for, you can say that, social status, legal equal status of all person, of all individuals, you can say that. And if we talk about equality before law, that is a negative concept that says that no person is above law, as the subjection of all persons should be equal. So you can say that is a concept of negative, you can say negative concept, while the equal protection of law says that the like should be treated alike, that is, you can say that, a positive concept, and they are meant for the same thing. And the Supreme Court held that where equals and unequals are treated differently, Article 14 doesn't hold. So Article 14 forbids class legislation, but it permits, you can say that, it permits some classification of objects, person, transactions made by law, but it should not be, you can say that, evasive, arbitrary, artificial, and rather it should be based on intelligible, you can say that, intelligible and substantial distinction, you can say that. So that is the concept, you can say that Article 14 says that equality before law and equal protection of laws. And in this there is a concept of rule of law. Rule of law. So what is rule of law? So you know that equality before law is an element of rule of law that was propounded by A.V. Dicey, a jurist, a British jurist, you can say that. And rule of law, you can say that there are mainly three provisions for rule of law, that are, first is that absence of arbitrary power, that is no person can be punished except for breach of law, you can say that. And second is that no person, whether rich or poor, high or low, official or non-official, is above the law, that is they should be treated equally, that is by the ordinary law administered by the ordinary law of land, that is Constitution. And the third element, the third provision of rule of law is that the Constitution, the primacy of all citizens, the Constitution is you can say that is the result of all citizens, of all individuals, rather than the source of all individuals, of all citizens. So you can see that in India the two elements, the first two provisions are applicable but not the third one, because in India the Constitution is the source of rights of individuals, it is not the result of rights of individuals. So you can see that rule of law is a very important concept propounded by A.V. Dicey, and the only two provisions are applicable to Indian system. And next is exceptions to equality. Exceptions to equality. So there are some exceptions to equality that are given to some individuals. You can say that, for example, the parliament and government enjoy some things that are the President of India shall not be answerable to any questions of his work done his office. You can say that. And second is that enjoyable. You can say that second immunities given to them are that the President of India and the Governor of states shall not be liable to any proceedings. There should not be any proceedings against them during their term of office. You can say that. And third is that you can say that no court can order of arrestment or any procedures against the President of India of any work done in his personal capacity until the expiration of the notice, expiration of 2 months notice given to him. There should be given a notice to the President of India, and after 2 months of that notice that was given to him, there can be order of proceedings, you can say procedures or arrestment, you can say that. And they are not, the president or governors are not, you can say there cannot be any order of arrestment, imprisonment, you can say any procedures against them during their term of office. And no person shall be liable to any proceedings if he has publicated some news on newspapers, radios, you can say that, or television. If that report is correct, that report is true, if he has, you can say that, if he has publicated some news of the parliament that is correctly true, then he is not liable to any proceedings, you can say that. And no member of parliament is liable to any proceedings, you can say that. No member of parliament is liable to any proceedings because of anything said or any vote given by him to the parliament or any other community thereof, you can say that. And no person of legislature assemblies is liable to any proceedings if he has said something, if he has given vote to someone or thereof, you can say that he is not liable to any proceedings. So you can see that these are some exceptions to equality. For example, foreign diplomats, sovereigns are, you can say that, enjoy their immunity, are not liable to any proceedings, you can say that. So our next topic is prohibition of discrimination on certain grounds. Prohibition of discrimination on certain grounds. So as we have discussed Article 14 of the Constitution, now comes the Article 15 that provides, Article 15 provides that state shall not discriminate against any citizen only on the grounds of sex, region, caste, race or place of birth. Now there are two very crucial words, very important words, you can say that are discrimination and only. Discrimination here means, you can say that discrimination means unfavorably distinction with citizens, with persons, with two individuals, you can say that. When you distinct two or more persons unfavorably, you can say that. And only here means that discrimination on other grounds is not prohibited. So prohibition of discrimination on certain grounds. There is on certain grounds, not on all grounds, you can say that. There can be discrimination. Many students feel in this question that they say that there should not be any discrimination on all grounds, but there is written only, that is that there can be discrimination on other grounds, and that this is the first provision of Article 15. Now the second provision of Article 15 says that no person shall be subjected only on the grounds of religion, race, caste, sex or place of birth to the access to the shops, wells, tanks, bathing ghats, you can say that, or any resort that is wholly or partly controlled by the state, or you can say that any place entertainment meant for public, that is meant for public, then any person, any citizen can go. can go there, can reach there, you can say that. And now Article 15 prohibits discrimination only to citizens of India. Here it is written as citizen, you can see that. So this right is guaranteed to only to the citizens. And the first provision of Article 15 is against only to the state, while the second provision of Article 15 is against the state as well as the private, you can say private companies, individuals, you can say that. So you can say that Article 15 prohibits discrimination on certain grounds, and well, there are some exceptions to it, that are, first is that the Parliament of India can make laws to the advancements of women and children. And second is that the Parliament is allowed, can enact any law in the favor, you can say that, in the advancement of socially, you can say that socially or economically weaker sections, or you can say that scheduled tribes, scheduled caste or other backward classes. And third is that the Parliament provides provision of reservation of socially, you can say that, socially backward classes, other backward classes, scheduled caste, scheduled tribes, you can say that, in educational institutions as well as public as well as private institutions, you can say that, except minority educational institutions. And fourth and last is that Parliament has made provisions, you can say that, for reservation of economically weaker sections up to 10% in educational institutions, including private institutions as well, but except the minority educational, you can say that, minority educational institutions. So you can see that there are some exceptions to it. And why are they? Because you know that the other backward classes are, you can say that, are not in line with the other, you can say that, other backward classes, scheduled caste, scheduled tribes. There have been made provisions for them. Why? Because you know that they are socially behind all the, you can say that, they are marginalized, you can say that. So that's why there have been made provisions for their advancements. So here comes reservation for OBCs in educational institutions. Reservation for OBCs in educational institutions. So you know that, as I've said, that there are exceptions to the Article 15, and one of them is that there are reservation for OBCs, other backward classes, in educational institutions, and that was added, you can say that, that was added by the 93rd Amendment Act of 2005, and after that the central government enacted, you can say that, for reservation they have been, you can say that, enacted a quota of 27%, enacted a provision for this, you can say that, providing a quota of 27% reservation of OBCs in all, you can say that, in all educational institutions, in all private educational institutions, including Indian Institute of Technology and Indian Institute of Management, you can say that. So you can see that this has been made, this provision had been made, the amendment was enacted, and amendment was made for the reservation of OBCs in educational institutions except minority institutions, you can say that. And in 2008 the Supreme Court upheld the validity, and you can say validity of both of Amendment Act as well as the quota for OBCs. And after that it said that, it held that, the Supreme Court held that the Parliament should exclude, the government should exclude the creamy layer of OBCs. Now what is creamy layer? Creamy layer is that, creamy layer of OBCs is that that are in higher, you can say that, that are in higher posts, that are not weaker sections, you can say that, that are advanced sections among OBCs. And the children of creamy layer would include the person who are in post of, you can say that, who are in post of President of India, Vice President of India, courts of judges of Supreme Court or High Courts, you can say that, or you can say that persons who are in the post of Colonel of Army of India, or in the Navy Force of or Air Force, you can say that, Indian Air Force, or the person you can say that whose gross annual income is above is above 8 lakh rupees, and the persons who are connected to the trade, business, you can say that, or the persons who are in the post of doctors, consultants, you can say that, or engineer, these persons, so far and so on, these are all creamy layer, that are advanced sections among OBCs, and their children would not have any reservation in these educational institutions, you can say that. So you can say that there have been made provisions for the reservation of, you can say that, OBCs in educational institutions, including all private institutions except creamy layer, you can say that. So next is reservation for EWS in educational institutions. Reservation of economically weaker sections in educational institutions. So you know that this provision was enacted after the Amendment Act, after the 103rd Amendment Act of 2019, and after that these EWS got reservation in all educational institutions, including all private except minority, you can say that, up to, you can say, 10%. As I've already said, they had got a reservation of 10%, and there is, you can say that, there is some eligibility criteria, that is, the person should be, you can say that, his gross annual income should be less than 8 lakh rupees, his gross annual income, his, or you can say that his family's gross annual income should be less than 8 lakh rupees, and here income would include all things, you can say that, all source of earnings, you can say that. Or you can say that if a person, his family should be, you can say that, if his family is possessing more than 5 acres of agricultural land, then he would not get any reservation in education institutions. Or if his family is possessing any of these, that are 100 square yards residential plot in notified municipalities, or 200 square yards of residential plot in other than in notified municipalities, you can say that these person will not get any reservation in educational institutions. And here if they are counting his incomes, his family's income, his family's earning, then they would, you can say that, they will apply to all incomes. They will, you can say that, they will join all incomes, that is, if they have land on that city, in A city or in B city, you can say that in both cities they have their lands, then both will be added to make his income. And here family would include that person's, you can say that, parents, spouse or children, you can say that. So you can say that these person, this is the eligibility criteria for the reservation in educational institutions. So next is equality of opportunity in public employment. Equality of opportunity in public employment. So as we have discussed till Article 15 of the Constitution, now we will discuss Article 16 of Constitution, of our first fundamental right, that is right to equality. So Article 16 provides for equality of opportunity in public employment to all the citizens of India. So you can say that no citizen shall be discriminated only on the grounds of religion, race, caste, sex, descent, place of birth or residence, to, you can say that, to be employed for employment in any, you can say that, public employment, you can say that, public office, you can say that, public post, you can say that. So you can say that Article 16 is for equality of opportunity in public employment, and there are 4 exceptions to it. Those are, first is that the Parliament can prescribe a residence as for the appointment in state, union territory, you can say that, or any in local authority or in any other authority. And as the Public Employment Act of 1957 expired in 1974, this provision is only in 2 states of India. Those are Andhra Pradesh and Telangana. So you can say that this provision is only in these 2 states, not in any other states. And second is that the Parliament, a law can be made to represent for the reservation, you can say to represent the backward classes that are not represented. You can say that a law can be made for the reservation of public employment for the backward classes that are not represented in government, you can say that, in the state, you can say that. And the third is that if there is an office, you can take example, if there is an office that is denominational or religion, then the government can provide for the incumbent of that office or any member of that office should belong to the same religion or to be denominational, you can say that. So you can say that a law can be made for this or parliament can prescribe for this. And the fourth and last is that parliament can, you can say that parliament can make provisions of up to 10% of reservation for economically weaker sections in public employment, you can say that. So you can say that this will be, you can say, if this provision is made, then it would be existing schemes, that is, it is made for the people who are not benefited for any other schemes. All schemes are made for particular person. If he is any person cannot be benefited, you can say that for 2 reservations, you can say that. So these are 4 exceptions, you can say that. So you can say that Article 16(1) says that, Article 16 Part 1, you can say Part 2, Part 3 and Part 4. So here it is, Mandal Commission and aftermath. Mandal Commission and aftermath. So in 1799, the Morarji Desai government appointed the second backward classes commission, that was Mandal Commission, and the first, you can say that first backward classes commission was appointed in 1953, that was chaired by Kaka Kalekar, and this was the second one that was appointed in 1979 and was chaired by BP Mandal, and that's why it is named as Mandal Commission. So its mandate was to survey all the backward classes and what should be done by the government for their advancement, and so it submitted its report in 1980, and it said held that the commission held the report that there were more than, you can say that, more than 3,400 castes of backward classes other than scheduled tribes and scheduled castes, you can say that, and there should be made provision of 27% of the reservation in public employment, you can say that, so that existing would be 50%, because there is a provision that all of the reservations in any, you can say, particular office should not exceed more than 50%, you can say that, exceed 50%, that was held by the Supreme Court. So the Mandal Commission said, you can say that, submitted its report and asked for 27% of advance of reservation of these, you can say that, backward classes, and for this, after 10 years, in 1990, the VP Singh government enacted, you can say, provided for a reservation of 27% of OBCs, other backward classes, in public employment if they are not benefited from any existing, you can say, the existing schemes. And Narasimha Rao government made more changes, it made reservations of 27% for, you can say that, for the poorer sections among the OBCs, you can say that, in employment, and it made 10% of reservation for the poorer sections among higher classes, higher castes, you can say that. So you can say that there were made provisions for both classes, for both castes, high caste and low caste, you can say that. And after that, in 1992, in the famous Mandal case, the Supreme Court held that there should not be any provisions of reservation for it, you can say that, it invalidated in it, you can say that it refused of the proposal of, you can say that, reservation of 10% for the poorer sections among higher castes, but it adopted this 27%, you can say that, 27% of reservation of, you can say that, poorer sections among OBCs, and it made some provisions, that was that the government should exclude the creamy layer, that are advanced sections among OBCs, as I've already said what they are, who they are, you can say that, and it should made, you can say that it should made reservation, but it should not exceed, you can say that 50%. There should be backlog, carry forward rule. There can be carry forward rule, that is backlog vacancies, but it should not exceed. It should not, you can say that, disobey the rule of 50% reservation. And a commission should be made, you can say that a commission should be made to mandate the over inclusion, under inclusion to the problems, you can say that, of, you can say that, backward classes. And Supreme Court also held that this existing reservation scheme would be for 5 years, for maximum 5 years. That was for 1997. If you see during that time, it was for 1997, you can say that, for 5 years, maximum 5 years. And to nullify these all points, this, you can say that the government of India did also, and its part, you can say that. So what they did was that they made commission, you can say that a commission, the Ram Nandan commission, to, you can say that, to survey, you can say that, to recognize the backward classes, to recognize the creamy layer of among OBCs, you can say that. And it made national commission for, you can say that, to mandate the over inclusion, under inclusion, upper inclusion among OBCs. And after 102nd Amendment Act of 2018, its, you can say that, its work was, you can say that, expanded. And for this, a new article, that was 338B, was inserted in our constitution. So you can say that, to identify, to, you can say that, to give enactment to these points that were, you can say that were held by Supreme Court. There were made many decisions by the Parliament of India. For example, for the vacancies, you can say that, and the 76th Constitutional Amendment Act of 1995 was enacted to, you can say that, to protect the Tamil Nadu reservation, because in Tamil Nadu the reservation for, you can say that, backward classes, scheduled castes, scheduled tribes, economically weaker sections is exceeding, you can say that, is more than 50%. It is 69%, you can say that, far exceeding for 50%. So for this, to protect this reservation, the 76th Constitutional Amendment Act of 1995 was enacted. So you can say that, to make all provisions of Supreme Court that were held in Mandal case of 1992, the Parliament has made so many, you can say that, has made changes, has made, you can say that, so many changes, laws, enactments for this. So next is reservation for EWS in public employment. Reservation for economically weaker sections in the public employment. So this provision was added in the Constitution by the 103rd Amendment Act of 2019. And after that, there would be 10% reservation. There would be 10% reservation for the EWS, that is economically weaker sections. And there can be posts, you can say that, offices that can be exempted from the purview of this Article 16, you can say that, and that are that any post or office, you can say that, any employment and lower than the group A, under the grades of lower grades in group A or group 1, you can say that, or any post that is termed as scientific or technical post in the views of cabinet secretariat, then it would be, you can say that, exempted from the purview of Article 17. And third is that they should be conducting, you can say that, organizing research or guidance. So these can be, you can say that, these can be conditions on which these posts, you can say that, can be exempted from the purview of Article 17. And our next subtopic is abolition of untouchability. Abolition of untouchability. So till now we have discussed till Article 16. Now comes the Article 17 that deals with abolition of untouchability. So Article 17 abolishes the practice of untouchability, and you can say that untouchability, the practice of untouchability, you can say that, is an offense in the view of government. And you can say that the Untouchability Offences Act of 1955 was renamed as the Protection of Civil Rights of 1955, Act of 1955, to expand its scope, you can say that parallel, you can say that, so that its meaning would be expanded, you can say that. However, the meaning of untouchability is neither given in the constitution nor in the amendment. You can say that there has been not defined, the term untouchability has not been defined anywhere, you can say that. But however, the Mysore High Court held that untouchability is nothing like, you can say that, in the sense of grammatical or literal meaning, but it's the practice that had been developed in our history, you can say that. So you can say that this is a practice, untouchability, that are given, that are introduced to some people or some specified people of some caste in those they were born, in which they were born, you can say that. So you can say that the untouchability has not been defined, but the Mysore High Court held that it is a practice that had been developed in our history, you can say that, and any practice of untouchability would be considered as an offense in the view of government. And you can say that this right is guaranteed, you can say that, against private individuals as well, and this right doesn't, you can say that, doesn't cover the part of social boycott, you can say that, in the matters of religious or etc., you can say that. So you can say that Article 17 is abolition of untouchability. So next and last is abolition of titles. Abolition of titles. So till now we have discussed till Article 17, and now comes the Article 18 of our fundamental right, first fundamental right, that is right to equality, and that says that Article 18 abolishes, you can say that Article 18 abolishes titles, you can say that, and there are 4 provisions for this. First is that the state is prohibited to give any titles on any particular body, you can say that, except the military or academic. If it's military, you can say that, then the state can give titles, or if it is, you can say that, any academic titles, then it is allowed. Second is that no citizen of India is allowed to take any titles from, you can say that, foreign country, you can say that. So you can say that there is a prohibition of titles, abolition of titles. And third is that any foreigner holding any post, office, trust under the state cannot, you can say that, cannot take any titles, cannot be conferred any titles, you can say that, from the state or anywhere. And fourth and last is that no citizen or foreigner, you can say that, no citizen or foreigner holding any post, office, trust is allowed to take any emolument, present, gifts, or any titles from the state. So you can say that Article 18 prohibits, abolishes the hereditary titles like Rai Bahadur, Raj Bahadur, and many more, so forth and so far. So you can say that Article 18 prohibits all hereditary titles. However, in 1996, the Supreme Court held that the national awards, like you can say that Padma Bhushan, Padma Vibhishan, these all awards, Bharat Ratna, they are not, you can say that, titles. They can be given to the, you can say, persons, you can say their names, because the Article 18 only abolishes the hereditary titles, and this is the merit, you can say that, these noble titles, that are noble titles, these Bharat Ratna, Padma Bhushan, you can say that their merit should be recognized, but however, these cannot be used as the prefix or suffix of the names. If there is an awardee, then he cannot, you can say that, use these awards as a prefix or suffixes of his names, you can say that. And if it is done, then the award should be fortified, you can say that. So you can say that Article 18 abolishes of all titles, abolishes all hereditary titles, but it allows, you can say, the noble awards. And the national awards that were started around 1953 were, you can say that, discontinued by the Morarji Desai government, but it was revived by the Indira Gandhi government in 1977. So you can say that from right to equality, our first fundamental right to equality, discuss Article 14 to Article 18, in which there is right to equality. There are some exceptions, you can say that there are some exceptions, but they are guaranteed to us, the citizens of India. We have discussed Article 14, 15, 16, 17 and 18. So we have discussed our first topic, first fundamental right, that is right to equality, and our next fundamental right is right to freedom. Right to freedom, that is our second fundamental right, and in this comes this right covers Article 19 to Article 22, and our first topic in this subtopic is in this protection of six rights. Protection of six rights. So Article 19 provides protection of six rights. In Article 9 there are six rights, you can say that, guaranteed by Article 19, and those are, first is freedom of speech and expression. Freedom of speech and expression, that is guaranteed by Article 19. You can say that this is the Article 19(1), Part 1 of Article 19. So every citizen of India has right, you can say that, has right to spread his views, beliefs, convictions in the word of mouth, printing, picturing, or in any other manner, you can say that. So you can say that every citizen of India has right, you can say that, of freedom of, you can say that, has freedom of speech and expression, and they can spread their views, beliefs in any ways, you can say that, by the modes of, you can say that, communication, by TV, press, radios, newspapers, writings, journals. They can spread their views in any ways, but this right doesn't include the right to strike. You can say that, you can say that no citizen of India has right to strike, and there are reasonable, the state can impose reasonable restrictions on them in this right, you can say that, and those reasonable restrictions are, they can be defamation, incitement, contempt of court, you can say that, sovereignty and integrity of India, and you can say that these are reasonable restrictions. You can say that morality of India, these are all the reasonable restrictions in which state can impose restriction on this right, not in any other, you can say that these are the only reasonable restrictions, not in any other, you can say that. And second is freedom of assembly. Freedom of assembly. So this is, you can say that, Article 19(2), Part 2 of Article 19, that says freedom of assembly. Every citizen of India, every person has right, you can say that, to assemble in peace and without arms. You can say that they have freedom of assembly, but this doesn't include, you can say that, riotous assemblies or that assemblies, you can say that, that create, you can say that, breach of peace, public peace, that create disorder in public peace, and they should be unarmed. The assembly should be unarmed, but you see that six, when you see six, that they carry swords, you know that they carry swords in their assemblies. So why are they allowed? They are allowed because this is their religious belief, and they are given freedom of their religion, which we will discuss in later in this chapter. Later in this chapter we will discuss six are allowed, you can say that, to carry swords, to be armed in assemblies, but their intention should not be, can say that, to harm anyone. So you can say that every citizen of India has freedom to assemble peacefully and without, you can say that, unarmed, you can say that, and there can be reasonable restrictions on them, mainly two, that are sovereignty and integrity of India and public order, general order, you can say that. So this is you can say that, reasonable restriction on this right, and you can say that these are given, these are provided, guaranteed by Article 19 under our fundamental right. And third is freedom of association. Freedom of association. So every citizen, you can say that, every citizen of India has freedom to form associations, cooperative, you can say corporations, you can say that political parties, they have, you can say that they have freedom to form associations. This include all, you can say that they can form companies, political parties, corporations, they can form any body, you can say that any body of person, they have freedom to do this, and this is guaranteed by Article 19. 19. So you can say that Article 19 provides for, you can say, freedom of association and to continue that association. It is not that only the association is made and you have not right to continue that association. You have right. Every citizen of India has right, you can say that, to continue that association as well. And but this right doesn't include that recognition of that association. The recognition of that association is not guaranteed by this right. You can say that freedom of assembly. It doesn't include the recognition of that association, and there can be reasonable restrictions that you can say that integrity and sovereignty of India and public order. These are mainly two, you can say that, two restrictions that can be imposed by state on this right. So next is freedom of movement. Freedom of movement. So you know that this right is also guaranteed by, you can say, Article 19, that is freedom of movement. Every person, you can say that every citizen of India has right to move in any part of territories, you can say move in any territory of India. He or she can, you can say that he can move in any part of India or any part in the territories of India, and you can say that this is a right of freedom of movement. You can say that they have right to move in any part of India, but there are, you can say that there is two restrictions, mainly two restrictions that can be imposed on this right, and those are, first is public order and second is, you can say, the scheduled tribes. No person has right to move in any tribal areas that are covered by tribal communities. This is because the distinctive culture, to protect the distinctive culture, custom, manners of the tribal communities, this restriction is made, you can say that, can be imposed. These are the restrictions that can be imposed. No person has right to travel, to move in any part that is covered by tribal community, that is the area of tribal communities, you can say that. And public order includes that any area that is militarized, you can say that is very, you can say that, high risk, high dangerous, you can say that there you have no right to move in that area. You can say that any area that is militarized, then you cannot move in that area. That is public order. Restrictions can be made, and the Supreme Court said that a restriction can also be made in order of the health of public. For example, the Bombay High Court validated the restriction of person affected by AIDS. The persons who were affected by AIDS were not allowed to move in any part of, you can say, all parts of India. So in terms of public health, you can say that health of public people can also be made restriction, imposed restriction by the state on this right. And next is freedom of residence. Freedom of residence. So you can say that freedom of movement and freedom of residence are complementary to each other, they overlap each other. You can say that they are almost same. And the freedom of residence says that, you can say that freedom of residence, according to the freedom of residence, every citizen of India has a right to reside or settle in any part of India. You can say that in any part of territories of India, and this includes two parts, that are, you can permanently set up in that area or can be temporarily set up in that area. It depends on you whether you want to set up in that area permanently or temporarily. But there are two restrictions on this right, reasonable restriction that can be imposed by state, and those are, first is public order and second is scheduled tribes. You know that you have no right, no citizen of India has right to reside in any part. You can say that to set up in any part, that is any part of India that is, you can say that is of tribal communities, tribal people, to protect their distinctive custom, culture, tradition, you can say, of any manner. So you can say that this right, freedom of residence, is guaranteed to anyone, but there can be reasonable restrictions as well. And next and last is freedom of profession, etc. freedom of profession, that is, this right says that you have freedom, every citizen of India has freedom to propagate any profession, trade, business. It depends on him. You can say that every citizen of India has right to propagate any business, any profession, and it is a very wide concept. It includes all means of earnings of a person. You can say that every citizen of India has right to continue any business, and you can say that there can be restriction only in one manner. The reasonable restriction that can be made on it is that for the sovereignty and integrity of India. You can say that there can be restriction on this right only on the ground of sovereignty and integrity of India. And according to this right, that is freedom to propagate any profession and etc., any trade, business, in this right, according to this right, the Parliament is empowered to, we can say that, to provide any to limit the qualifications for necessary. You can say that if there is a post, and for that post the Parliament can prescribe any qualifications that can be scientific, technical, in any ways. So Parliament can prescribe qualifications for any post, you can say, for any business, and Parliament is empowered to take any trade, business, or you can say that whether monopoly, whether completely or you can say partly. That is, Parliament is empowered to take any trade, business, to carry on that trade or business monopoly. That is, the Parliament has its monopoly on all trades, business. So you can say that freedom of profession, you can say that, is provided to every citizen of India. So these are all 6 rights that are guaranteed by Article 19 under the second fundamental right, that is right to freedom. And earlier there were 7. There was one more, that was right to acquire or hold any property, but it was deleted by 44th Constitutional Amendment Act of 1978. And after that there are only 6 that are freedom of speech and expression, that we have already discussed, freedom of assembly, and one more important thing, freedom of assembly, is that there can be restriction, there can be imposed restrictions, and according to the 144, you can say that section 144 of criminal procedure, a magistrate can restrain, you can say that can restrain on the practice of assembly. You can say that he can impose restriction according to the section 144 if it is meant for people, you can say that public health, public order, you can say that. So the magistrate can impose restrainings on the, you can say that, freedom of assembly. That means you can say that a curfew is imposed, and a curfew is imposed, then it is meant for people, us citizens, then it can be imposed, curfew can be imposed, and this right is not covered by, you can say that, right to assembly. So you can say that we have discussed all 6, and earlier they were 7, and after, now at present time they are only 6. So next is protection in respect of conviction for offences. Protection in respect of conviction for offences. So Article 20 provides for, you can say that, protection in respect of conviction. You can say that if there is a conviction for offences, then Article 20 protects that person, and there are 3 provisions. You can say that there are mainly 3 provisions in that, and those are, first is no ex post facto law. So first let us discuss what is a ex post facto law. So ex post facto law means that you are providing conviction, you can say that, retroactively. That is, if it was a conviction, he had done offense at some years ago or some time in the past, then you cannot, you can say that, you cannot convict him now at present time. So in India, you can say that Article 20 provides no ex post facto law. That is, no person can be convicted for his offense done in the past at the present time, and the law that was made for that offense should be applied. That is, if he had done an offense and he is being convicted, then the new laws will not be applied. The laws that were made during that time, during the time of offense, will be imposed, you can say that, will be convicted for him. So you can say that in India there is no ex post facto law, that is what is called as retroactively. In India there is no, you can say that, practice of retroactively conviction, and this conviction is only for criminal procedures, not for, you can say that, civil laws, taxes. You can say that these no ex post facto law is meant for only criminal procedures, criminal conviction, not for civil or tax, you can say that, revenue, all these. And the second provision of Article 20 is that no double jeopardy. No double jeopardy is that if a person was convicted for an offense, then he cannot be convicted for the same thing twice. That is, if he had been convicted for an offense, then he cannot be convicted again for that same criminal, you can say that, criminal offense. So this is also applied only on criminal procedures, only on criminal convictions, not on civil, you can say that. So you can say that double jeopardy, that is a person had done an offense and he is being convicted 2 times, 3 times or more times. But no double jeopardy, that is a person had done an offense and he cannot be convicted twice for it. And third provision of Article 20 is that no self-incrimination. No self-incrimination, that is a person, a citizen cannot be expelled. You can say that a citizen cannot be compelled to expel a witness against him. So that means you may have seen in movies, in Hollywood movies, that whenever American police, American cops capture any person, then they warn by Miranda warning. And what is Miranda warning? So Miranda warning is that, you can say that, this right, no self-incrimination is right to remain silent, you can say that. So that means Miranda warning is given to them because to show that anything that you say can be, you can say that, can be used against them in the court. So you can say that no self-incrimination means that you cannot be compelled to be a witness against yourself in time of conviction, and that is what is given in the America as Miranda warning, and that is in India it is no self-incrimination. And in this no self-incrimination there are some parts that are not covered by it, that is any blood specimens that are taken by, you can say, taken for that procedure cannot be counted in that article. In this right, you can say that these rights, that are thumb impressions, documents, writings, these are not covered by this right. So you can say that these are, the no self-incrimination provides for that you cannot be compelled to be a witness against yourself, and you cannot be, in this you can say that no narco analysis, no brain mapping, brain scanning, brain testing, these cannot be done for you. You can say that that is what is under no self-incrimination, and that is what provides Article 20. Article 20 is to protect any, we can say that, convicted person for an offense. You can say that it is in respect for protection of conviction for any offense, you can say that. So our next subtopic is protection of life and personal liberty. Protection of life and personal liberty. So till now we have discussed till Article 20, and now comes Article 21, that is protection of life, that provides, Article 20 provides protection of life and personal liberty except according to the procedure established by law, and this right is conferred, is given, you can say, is provided to all, to citizens as well as foreigners, you can say that. So you can say that protection of life and personal liberty except procedure established by law. Procedure established by law, what do you mean by it? Procedure established by law means that in A.K. Gopalan case of 1950, the Supreme Court held that procedure established by law, that is a law is made by Parliament, and according to the procedure established by law, you don't have to see how is the law, is it unjust or fair, is it unjust or unfair or fair, you can say that it doesn't have to be seen, but you have to see procedure, you have to follow that procedure established, that was established by law. A law is made by Parliament and it gives a procedure, and we have to follow that procedure, not though we don't have to see that law, how is it just or unjust, we have to see it, but according to the procedure established by law there is not, we don't have to see. law can be unfair or unjust. We have to follow, we just have to follow procedure, you can say that, and that is what Supreme Court ruled. Supreme Court ruled in A.K. Gopalan, in famous A.K. Gopalan case of 1950. So you can see that in India during that time there was, you can say that there was procedure established by law, not due process of law, that is in America. And again in 1978 in the famous Maneka Gandhi case of 1978, Supreme Court overruled its judgment of A.K. Gopalan case. So that means due process of, in Maneka Gandhi case, it was that her passport was taken just by saying that it was because of Passport Act, but she was not given why was her passport was taken, and she was not given the proper reason. She was told that according to that law your passport has been taken, you are not allowed to move any part of, you can say that, in any part of the world. And in that case Supreme Court overruled its judgment of A.K. Gopalan case. It then established the due process of law. Due process of law, that is, if there is, you can say that if there is an action and according to the law we have to see law whether is it just or unjust. We don't have to follow the procedure. First we have to see the law according to which, because in Maneka Gandhi case it was wrong, but they had to see firstly their law. So in 1978 in Maneka Gandhi case, you can say that Supreme Court established due process of law, and after that there comes, but in the Constitution there is still written as procedure established by law, and according to the case there is Supreme Court says procedure established by law, due process of law. So according to the cases it can be differential, it can be procedure established by law or as well as the due process of law, but in Constitution it is written as procedure established by law. And in Maneka Gandhi case, Supreme Court gave, you can say that, gave a wider expression of personal liberty. Protection of life and personal liberty doesn't mean only that he is living, but he should be living. The person should be living with his personal dignity. Personal liberty means with his dignity, with his choices, you can say that. The person should be given freedom, and after that, in that case, Supreme Court gave a wider expression of personal liberty, and under Article 21, now there are so many rights, there are very many rights, you can say that, like right to shelter, right to privacy, right to medical aid, you can say that, right to education, right to live with personal dignity, you can say that, right to live in decent environment with pollution free, you can say that. So you can say that there are many rights under Article 21. After that Maneka Gandhi case, Supreme Court gave many rights under Article 21. And Article 21 was, you can say that, is very important, is most important in our, you can say that, is the most important article in our Constitution, you can say that, because you know that if you are hurting Article 20, if you are hurting, that is ex post facto law and no double jeopardy and no self-incrimination, and if you are hurting that, if you are not following any of them, then what you are hurting? You are hurting his personal liberty, that person's personal liberty. If you are not following the procedure for the conviction as the no ex post facto law, no double jeopardy, no self-incrimination, then what you are hurting? You are hurting that person's personal liberty. And after that, what do you violate? You violate the Article 21 of our Constitution. So you can say that Article 20 is protecting our Article 21. So you can say that Article 21 is very important, and that's why it's being protected. And next is right to education. Right to education. So as I have said that right, protection of life, Article 21 says that right to education should also be provided, and that's why right to education, Article 21A says that there should be right to education. All children between the age of 6 to 14 years should be given education. You can say that every children of India, every child of India, every kid of India between the age of 6 years and 14 14 years has right to education. He can go schools. So you can say that right to education under Article 21A provides for elementary school, elementary education, not for higher education. And before, earlier, this provision was added by the 86th Constitutional Amendment Act. But before that amendment, this provision, that was amendment 86th Constitutional Amendment Act, before this amendment there was a provision of, you can say that, of educating the children, but it was in the Article 45 under the Part 4 of the Constitution, and because of being a directive principle, it was not enforced, it was not justiciable by the Supreme Court or any court, you can say that, because it was during that time, it was a directive principle of state policy, it was not a fundamental right. You know that fundamental right is provided to all citizens and directive principle of state policy is not. So you can say that because of it was not enforceable by the courts, so because of it was made a fundamental right under Article 21A, and now Article 21A says for right to education. What about that Article 45? Now it is written as that the state shall endeavor of education to all the children of up to the age 14 years. That is, the state has to provide education all the children, all the kids between the 6 years to 14 years, and it is also fundamental duty, that is, every citizen must give education to his ward or kid up to 6 to 14 years. So you can say that there is right to education to all children of India between the 6 to 14 years, between the age of 6 and 14 years. He can take education, he should be given, he must be provided education, and after that it depends on economical, financial problem, status of that family. And because of right to education, there was provision, there was made a provision, you can say that there was enacted an act, that was Right to Education Act of 2009, and that says that every child must be provided education, and he should be provided education, but in satisfactory, you can say that in satisfactory condition. That means if he is going to school, then he should be provided all facilities of a school. That doesn't mean that teacher is not qualified and the school is very, you can say that, is not suitable for that kid. It should be suitable for that kid, teachers should be qualified, you can say that. So you can say that education must be provided and a good quality education also must be provided, and that is what Article 21A says. Protection against arrest and detention. Protection against arrest and detention, that is Article 22. We have discussed the Article 21A. Now comes the Article 22 that grants protection against arrest and detention. So detention can be of two types, that are punitive detention and preventive detention. So punitive detention, that is a crime has been done, trial has been done, convicted has been done, offense has been done, and after that you are giving him punishment, that is punitive detention. And preventive detention is that, you can say that an offense has not been done, but to prevent him from committing any offense in future, you can say that you are giving him detention. So this detention is of type that you are preventing him doing any crime in future. So you can say that there are two types, and Article 22 is divided into two parts. First is for ordinary laws and second is for preventive laws. Preventive detention, that is according to ordinary laws, it is the first part of Article 22, and according to it is that if you are detaining a person has been detention, then you have to tell him why he is being arrested, why is he being detained, because a police, you can say that police force cannot arrest any person for no reason. They have to tell him why he is being arrested or detained. And second is that after, you can say that within 24 years, within 24 hours, the police has to, you can say that person, that detained, arrested person show up before a magistrate. You can say that they have arrested a person and within 24 hours they have to, you can say that, present him before the magistrate. And you can say that if there is any trouble for you can say that reaching to magistrate within 24 hours, then it is okay. If there is a reasonable reason, then it can be extended for more than 24 hours. But with formality, it should be 24 hours. Within 24 hours, the police must, you can say that police must show that arrested person, present that arrested person before magistrate. And if there is no, you can say that magistrate has shown no, you can say that a magistrate has, you can say, given no orders for his arrestment. That is, if he is shown to the magistrate and after that magistrate has given no orders for his arrestment or imprisonment, for his detention, then police has to leave him, you can say that police has to leave him, you can say that within 24 hours. They have to leave him, they have to, you can say that, unarrest him within 24 hours. But there can be conditions, but they have to give him, you can say, bail under 24 hours. And you can say that he should be provided, that arrested person should be provided a legal practitioner. That means if he is arrested, he is being detention, he has been detained, then the state, it is a responsibility of state to give him a lawyer. If he is not, you can say that if he is unable, disabled to take, you can say that to hire a lawyer, then it is the responsibility of magistrate or state, you can say the court, to give him a legal practitioner, that is the lawyer, because it is the right under, you can say that under Article 22, that every citizen, every person must be provided, you can say that a lawyer, a legal practitioner in his defense. And this is about the ordinary laws. And according to preventive, we can say that in preventive detention, it is that for the maximum period of arrestment for preventive detention is of 3 months, and it can be exceed, or you can say minimized, only by an advisory board, only by the, you can say that only by the report of, you can say that only by the advice of advisory board. If advisory board wants, then it can be exceeded, or you can say that it can be minimized. So you can say that for preventive detention there are some other rules, and under preventive detention the parliament has been empowered to prescribe any, you can say that circumstances, cases, classes, to maximize, you can say to exceed, to expand time period of detention, you can say that without taking, you can say that without taking the report, the advice of advisory board. And second is that the parliament can prescribe, you can say that can prescribe the maximum period of, you can say that of detention, of preventive detention. And accordingly the parliament, you can say that by the constitution, by the 44th Constitutional Amendment Act of 1978, had reduced the time period for preventive detention from 3 months to 2 months. But this provision has never been enacted into reality, you can say that had never been enacted. You can say that this provision was made, this provision was amended in the constitution, but had never come into, you can say that had never come into enforce. You can say that part 2 of our Article 22 part 2 has never been enforced by the courts or anyone. So you can say that Article 22 provides to Parliament to prescribe any of these, and this was done by 44th Amendment Act, but it had never been come into force. And there are some laws, you can say that there have been some acts that were enacted by Parliament for preventive detention, like for example Preventive Detention Act of 1957, and for UAPA, that is Unlawful Activities Prevention Act, and that is also at present, that has been amended by so many times, and now it has been latest amendment in that act has been done in 2019. And there have been so many acts, for example NSA, National Security Act. So you can say that Parliament has power to make laws, to make acts accordingly for the preventive detention. And it is, you can say that preventive detention is an integral part of our constitution, but it has never been done in any part of the country, in any part of the world, in any country of the world. No other country in the world has made, you can say that Article 22, that is preventive detention, as an integral part of the constitution. So you can say that in the world, India is the only country which has made the preventive detention as an integral part of the Constitution. And we have discussed in this video, this is the first part of this chapter because its content is so much. So it is the first part of the chapter. We have discussed two fundamental rights, that are right to equality and right to freedom. And in this we have discussed from Article 12 to Article 22, and we have discussed different things like definition of state, laws inconsistent with fundamental rights. And we have, because in this chapter, from this chapter, many questions are asked. So this is, we have discussed in the first part of the chapter. This is all in the first part of the chapter, and the remaining part of the chapter will be discussed in the part 2, in next part of this chapter. So thank you very much.